If you have been living with chronic pain, constant fatigue, or cognitive difficulties since your time in service, but a doctor has never given you a diagnosis, you may have been told you cannot file a VA disability claim. That is not necessarily true, and today I want to explain why. My name is Brad Hennings. I'm a partner at Chisholm Chisholm Kilpatrick, and before joining CCK, I spent years as a veterans law judge at the Board of Veterans Appeals. I've seen thousands of these cases from both sides. Even many claims processors don't understand the law here, so let's walk through it step by step. Let me start with the basic question. Can you file a VA claim if you do not have a formal diagnosis? The answer is, in many situations, yes, and the reason comes down to a 2018 federal court decision called Saunders v. Wilkie. Before that ruling, VA operated under a long-standing rule. To get service-connected for a physical condition, you needed a diagnosed medical condition. Pain without a name was not enough. Saunders changed that. The U.S. Court of Appeals for the Federal Circuit, one of the highest courts in veterans law, held that the word disability in the governing statute, 38 U.S.C. 1110, refers to functional impairment of earning capacity, not to the underlying cause or diagnosis. In plain language, if your symptoms are real, service-related, and limiting your ability to work and function, that can qualify as a compensable disability, even without a named condition attached to it. So what does that mean practically? Take chronic pain as an example. Imagine a veteran who spent years doing heavy physical labor in service, loading equipment, long ruck marches, repeated physical strain. After separation, they have persistent back or knee pain. Doctors run tests, x-rays are normal. There's no arthritis finding, no structural damage they can point to. The examiner says, essentially, I cannot give you a diagnosis. Before Saunders, that veteran was stuck. After Saunders, that veteran may be entitled to benefits if their pain reaches the level of functional impairment. That means it is limiting their ability to walk, stand, lift, work, or perform the activities of daily life in a meaningful way. That same logic can apply to chronic fatigue and certain types of cognitive difficulties, symptoms that many veterans experience but that resist clean diagnostic labels. Now, there are real limits here. This is important, so let me be direct about them. First, simply reporting pain or fatigue is not enough on its own. Saunders does not mean VA has to take your word for it. The functional impairment must be demonstrated through medical records, treatment history, lay statements, and ideally a Nexus opinion from a qualified provider linking your symptoms to an in-service event, injury, or disease. Second, the other two elements of service connection still apply. You still need evidence of an in-service event or incident, and you still need a medical link, a Nexus, connecting that in-service occurrence to your current symptoms. Saunders removed the diagnosis requirement for the first element. It did not remove the Nexus requirement. Third, and this is where many veterans get tripped up, for mental health conditions, a formal DSM-5 diagnosis is still required, even after Saunders. That is because VA's rating schedule for mental health conditions explicitly requires a diagnosis. So while Saunders applies broadly to physical symptoms, it does not eliminate the diagnosis requirement for psychiatric claims. If you've struggled with chronic pain, persistent fatigue, or other symptoms that have resisted formal diagnosis, know that the law has recognized that your symptoms can matter. And if you've been denied in the past, it may be worth taking a second look. Take care.